With that, we will move on to our first special report, which is from Judicial Information Systems Committee and the request for support for adoption of revisions to JISCR 13. And with us, we have Administrative Office of the Courts Liaison to the JISC, Vicki Cullinane. Vicki, are you here?
I am. And
wonderful, welcome.
Remember to take myself off of mute, which I think is like going to be on everybody's T-shirts by next year. You're on mute. If you will indulge me, I also have some bonus content that you may not have heard already from Bob Taylor, your JISC representative. So the reason I'm coming before the board today, Bob could not be here, is to ask for the board's support in getting amendments to JISC Rule 13 finally passed after, I think, something like 8 years of working on it. So maybe it's not that long, but it just feels like 8 years. So this all started in 2013. Now, mind you, the rule has not been amended since like 1976, so it probably needed to be amended anyway. But it came to the forefront in 2013 when we became aware of a number of courts that were planning to get independent case management systems. And you may all be aware that Seattle Municipal Court has always had its own case management system, and Pierce Superior Court also. But there were like 5 to 7 other courts that were talking about doing that. And we did not have any sort of a technology mechanism to share data with them. And these courts were basically saying to AOC, well, you have to drop everything and, work on our thing so that we can share data with you. But we already had a lot of things in the pipeline. The Superior Court case management project was in, midstream, and we had resources already lined up to do other things. So the JISC came up with data standards, which we workshopped for about 1.5 years with, courts with independent systems and statewide stakeholders. And so they passed those in 2014. But the problem, and the JISC has the power to do this, the problem is that there's no enforcement mechanism. It just says, you shall do this, but there's no way to make courts do it. And at the time, there was no way to share data that wasn't manual. We have since then built a data repository, which is called the EDR. But that was done because the last time around, basically, the data standards say, if you are a court that goes off on your own and AOC doesn't have the resources to hook you up electronically yet, then you have to enter certain data in that is needed by other courts and practitioners and the public, for public safety reasons, for access to justice reasons. Then you have to enter it in manually until such time as we can get those resources. So now we have the mechanism, but the reality is that that even though we have the mechanism, it has been, I think we started that project in 2015. So it might have been started in 2014. It's been 5 years. And so far, there's only one court that's been connected, King County Superior Court Clerk's Office. We've been working for the last 6 years with King County District Court and King County Clerk's Office to get them connected through this EDR. It just takes a long time, and it's a lot more work than anybody realizes. And actually, the majority of the work is on the other side. It's on the side of the court with the independent system. And so we came out with some information for other courts that were thinking about getting independent systems. But I don't know. I think there's a phenomenon that happens. It's kind of like the easy button. They get this idea that they're going to get a separate system and that creating this data exchange is going to be really easy, but it's really not as easy as they think it is. And so the first time the rule passed the JISC almost unanimously and went before the Supreme Court, and then there was opposition. I believe it was all out of King County, primarily from the King County Clerk's Office. This was before, we had the project to make the data repository and all of that. And so the JISC withdrew the rule at that point because it was too controversial. It just looked like it wasn't going to pass. And then 17 or 18 rolled around, and the same sort of thing started to happen. There was now another bunch of courts that were saying we're going to get our own separate systems. And the problem with not sharing the data is you get a fragmentation. And any of you who may practice with Seattle Municipal Court using any sort of a statewide system will know that not all the data is there that you may want to see in order to do your business. That's true for judges. I hear it from judges all the time that get frustrated that they can't see everything they need to see. That is now happening with the King County Clerk's Office because they're not sharing everything that judges that also practice in King County want to see. And I'm sure that it's true for all of the other practitioners who can't see information they want to see. It's a public safety issue and, again, access to justice issue. So it came back before the JISC in, I think it was 2019. And it was once again kind of controversial. And at that point, the proponents of amending it wanted to make the stick, if you were, even more draconian than the first time around. The original draft said, if you don't do this, if you don't enter this data manually until such time as we can hook you up, you will not get funding for your equipment. There's money that AOC passes through to local courts for computer equipment, and that was seen as too harsh. Well, when it seemed like it was getting out of control again, there were proponents of sort of the statewide view of things who said that's not harsh enough. We want it to be more harsh. And so the proposal was that courts that didn't comply would lose all of their funding from AOC. Well, everybody lost their minds with that idea. And so given that this has had such a checkered past, by the way, after the first time that they couldn't come to agreement, the chair, Justice Fairhurst at the time, set up a work group to try to come to some agreement. They worked for 2 years. I staffed that committee for 2 years, and they went back to like a hung jury. They went back to the JISC twice and said, we can't agree. Can you help us out? Got no guidance. And so 2 years passed and nothing happened. So this time around, knowing that history, Justice Fairhurst was still the chair at the time. She set up a special work group that was very carefully crafted to have, equal representation from kind of both sides of the issue. And so it's the memo that I prepared for the board has the members of that committee, but it included Judge Tucker from King County District Court, Judge Alf from Olympia Municipal Court, which is going on their own system, and so on. I mean, it's people from both sides. And they used this method that some of you may know called Fist to Five, where you have to hold up a certain number of fingers that you agree or you don't. I'm telling you, I staffed that committee. That was the worst committee I've ever staffed because they argued over every single word, the ands, the commas, everything. And they hammered out an agreement. And it's much watered down from the original, but at least it's some kind of guidance, and it kind of sets out how things will work, and that courts can't just demand that we drop everything and work on their thing, that there's a process of IT governance, and everybody has to wait their turn and all that kind of stuff. And we only have so many resources. So that's basically this lays that out. And rather than providing any particular penalty, if you will, what they agreed on is that any disputes between that court and AOC about how much data they have to share for any interim period between when they go live and when they're connected, that those disputes will go to the JISC. JISC is the sort of the BJA equivalent for technology. So the BJA covers all other kinds of policy issues in the judicial branch. JISC covers, any spending and oversight of any projects related to IT. So that's the compromise that they came to. Again, it's pretty vanilla, but it's still much more helpful than the original language. And unlike the last time around, it's gotten considerable support. Most of them are not filed on the website yet, but I am aware that, and I think I had that added to your packet, that the Access to Justice Board has supported it. The Office of Civil Legal Aid has supported it. And I am aware of 5 other representatives of the judicial community that are planning to, or the judicial branch who are planning to write letters of support. They're in some, stage of the process of doing so. And so I asked Bob Taylor as a JISC representative if he would support the rule. And I know he had a conversation with your president and wanted to have this presented to the board as a whole. So that's why I'm here. And that's my spiel. Any questions?
Governor Grabicki.
As a board, we've discussed several times the issue of each county doing its own thing and how disruptive that is and how uneconomic it is in terms of the entire system. And most of us are familiar with PACER, the federal system, which is light years ahead of anything that we have here in the state. Have you all looked at an approach which would result in a statewide system like PACER?
We have a statewide system for, they're separate systems, but they all share data so that anybody using any one, so there's a JABS is the system that judges, prosecutors, and public defenders use to view information. They don't, put information in, but it pulls information from all of our other systems so that judges and prosecutors and public defenders can see all of that. We have a system for juvenile courts. We have a system for superior courts, and it has just not that long ago been completely replaced with Odyssey. And we have a system that was homegrown in the 1980s for limited jurisdiction courts that we are in the process of replacing with also Odyssey. And all of these systems talk to each other and have data exchange between them. The difficulty is because this is not the structure of the courts in this state is not centralized. We don't have the power to tell courts you cannot do this. They can. And Rule 13 was written in 1976. It anticipated that courts would do that because it talked about a process. It wasn't very well written, but it talked about those courts needing to go to the JISC for approval before doing that. So and from day one, Seattle Municipal Court has said, nope, we're going to go on our own, as well as Pierce Superior. So in our ideal world, everybody would be on the same system. Nobody would be on their own system, because even if you've got courts connected through this data exchange, it's imperfect, because the reality is even with two modern systems, they just don't operate the same. So the system that superior courts are using statewide is Odyssey. The system that King County Clerk's Office is using is called eCourt. Well, eCourt is not person-based, it's case-based. So if you go into the statewide system and you want to find a person's criminal history, we have to do a whole lot of behind the scenes matching up to make that come together so that you can see that person's criminal history in the system. So it's actually taking 8 full-time people just to do the work behind the scenes so that somebody using the statewide system can actually see everything. It's just doesn't work as well. So if we had our druthers, yeah, that would be great, but we can't force them.
If your rule amendment is adopted by the court, wouldn't you then be in a position where you could say we're only going to approve one system, and every county is going to have to use it?
No, it doesn't do that. And that's just politically untenable. I mean, we just can't get there. I mean, it's been discussed over many years, and there's just no appetite in the judicial community for the state to say, local government, you shall do X. And in fact, some of you may be aware of an agreement that we made that was a compromise that a lot of people now regret on the Superior Court project, that county clerks wanted to keep their own document management system. So in about half of the state, if you're an Odyssey user and you have the right, access rights, you can see documents. You can connect case information with actual documents that have been filed. But in half of the state, you can't, because those county clerks chose to use their own system. And they were so recalcitrant that we ended up making this devil's deal in order to keep them inside of the project. But now, everybody hates it. So we just don't have the power to do what you would, believe me, I would like that just as much as you would, but it's not going to happen.
All right. Thank you for the discussion. I will move that we pass a motion supporting the amendment to the rule.
I'm going to leave that motion floating there and continue off discussion. Governor McBride, Governor Tolleson, and then Governor Clark.
Thank you, Mr. President. Vicki, thank you for being here. Just a kind of I think you touched on it a little bit with the Superior Courts and with Odyssey. What's the current status with Pierce County Superior Court right now? Are they still on a separate system, and is the underlying inability to force the issue basically based on who pays most of the freight on the systems? And it's King County. It looks like King County maybe has changed their position. Could you just talk about that a little bit?
Sure. So Pierce County Superior Court chose not to opt in when, they were absolutely offered the opportunity to be part of the statewide system when we replaced it for Superior Courts, but they chose not to. They actually tried to get the state to adopt their system, but there were some very practical reasons why that wasn't doable. But we spent a couple of years on a study, and that was one of the options that was looked at. So when we said, no, we're not going to adopt your system, they said, well, we're not going to adopt your system. So it passed. And as far as I know, they're still following that path. However, we need to some of the old systems that were built in the 70s and the 80s at some point. And unfortunately, there are some processes behind the scenes that have threads connecting the old system that was previously SCOMIS, which was used by Superior Courts, with that Pierce County is still using. So we have a long-term plan to try to get them sort of moved over. And one of those options we have offered that, you could opt in. There's a cost to us to do that, but it would be easier than all of the other things that would have to happen. So that, I suppose that's still a possibility, but that's kind of part of our longer term plan because there are so many things that have to be unraveled in order to turn off the old system. And somebody raised the issue a couple of years ago, and every time we had a meeting about it, it got more and more and more complicated when we realized all of these connections. It's like the most incredible spider web you've ever seen. The first time I saw a diagram of how all of these different data connections were between our existing systems, because they were custom built, they were not built in like a way that it would be done in today. That would be much more practical and easy to unravel. So we're working on it, but I don't know how that's going to come out, because either they would adopt Odyssey or we've got to build a whole bunch of other data exchanges that accomplish what they're using in SCOMIS right now.
Governor Tellefson.
Can you hear me all right, I hope?
Yes, sir. Okay.
Governor McBride pretty much asked the questions I was going to ask. I was just going to say the Pierce County system was started way back in the early 1990s and kind of predated some of the graphical interfaces that the state finally decided to adopt. And I think the big problem with trying to get Pierce County to move over is that their legal information exchange system covers way more than Superior Court. It's tied into some of the other county departments, and so that's probably why they don't want to move over, because then they'd lose the functionality. That's just my recall, because I was heavily involved in that whole project as a representative of Superior Court for many, many years. So that's that question. Now that's that comment. The only question I wanted to ask was, the rule as I read it only covers upgrades or new systems and doesn't cover any of the existing systems, right? So that's why everybody is signing off on it, because the people that already have their individualized systems in place, they're not going to be affected by the rule. Is that the way you read it?
Yes and no, I guess. So the status quo right now is that we've got Seattle Municipal Court, and we have a long-standing but limited data exchange with, and we have Pierce Superior Court, and you're right about they've got local connections with links that make it kind of impractical for them. And I don't know enough about what that problem would be, because we got problems of our own. So it's those two, but for many years, Pierce Superior Court entered their data manually. And I think that they built some sort of, I forget what you call those things, but these sort of automated processes that did some of that work. So it wasn't like a human being necessarily putting that all in. And And then, but we were paying them a certain amount of money every year for staff to do that. And at a certain point, we said, we can't keep doing that. And we spent $2 million on a data exchange that was an more old-fashioned kind many years ago. And then, and that took a while, but then it was AOC had to do the work on our end, and then Pierce County had to do the work. And when Pierce County started to do the work, they were saying, oh, we'll be done in 2 months or something. And then exactly the same thing that always happens is, oh, we didn't realize it was this hard and this complicated. And it started taking longer and longer. And then apparently they have a local IT governance structure that didn't even have judicial representation. And that body said, we've spent $300,000 so far, and we're not even close to done. So we're pulling the plug. So that was just thrown away work. But the good news was that about a third of the data, as I recall, they had already made about a third of the connections. So what we have right now is kind of a partial manual and a partial data exchange with Pierce County. And I haven't spoken to local Pierce County practitioners to know if it's working for them, or for other people who practice in Pierce County that, have to interact with that system and the statewide systems. I don't know, but so we have partial. And then what kind of sparked all of this was Spokane Municipal Court in 2012 said, we're getting our own system. And this is how the whole thing kind of, bloomed. And what they're doing is they agreed after much discussion to hand enter the data. But then what actually happened in reality, and again, because no enforcement mechanism, is that they just only enter a very minimal subset that they have decided is sufficient for public safety purposes. AOC doesn't agree about that, but we haven't been able to, we've written them nasty grams and stuff, but it hasn't really made any difference. And there was somebody from Spokane Municipal Court who was on that group that came up with this language. But right now, where we are is we're about to wrap up working with King County, so that will be automated. And we have started working with Seattle Municipal Court because they actually considered getting on the statewide system, but lots of stuff happened you don't need to know about, except at a certain point they decided, nope, we're going to go our own way. But they've been very good to work with. And so they are in the process of upgrading MSIS to a new system. And we are working cooperatively because they already had sort of a placeholder in our IT governance process years ago. So as soon as they were ready to go to their new system, we started working with them for the data exchange. So that will get a lot better in a couple of years when they have rolled over to their new system and we have a robust data exchange. People in King County and surrounding areas will be able to see a lot more about what's going on in Seattle Municipal Court. And Spokane Municipal Court is also upgrading its system. So what we consider we reached an impasse, and some people got grandfathered in at like whatever their level was in 2014 of manual input. But as soon as those courts go to do something new, we consider that a brand new, request. And so they've got to work with us in order to do this data exchange. We're not offering them another option. So we have kind of an imperfect status quo, but for anybody who wants to either upgrade an existing separate system or get a new separate system, they have to follow this process. So that's where we're at. Does that answer your question?
Okay.
Thanks so very much for that very extensive answer. It's more than I asked for, but yeah, I understand all the complexities of this stuff, and you're right. It's because you've got different systems and different technologies, and trying to make it all work together is a huge project.
Yeah, sorry for oversharing. I've been living and breathing this for so many years, I get carried away.
I'll second the motion.
Okay. I left that motion floating as a matter of discretion. There's a second made by Governor Grabicki. It was seconded by Governor Peterson. Somehow lost my pen in the process of lunch. Any other discussion on this matter? Seeing none, I will... Governor Stevens.
So I'm trying to follow the bouncing ball here. If we vote for this motion, what comes of that? how does this move what you're trying to do further along?
That is the best question I've heard all day, Governor Stevens, actually. Governor Grabicki, if I recall his motion, was that we do what was asked, which is support the motion. However, the work product that will probably come out of that is that the president, whoever the president is at 5 p.m. at the end of the meeting on Friday, will have to write a letter on the comment of the rule before the Supreme Court. Is Governor Grabicki, was that your understanding of what might come out of this?
Yes.
Governor McBride?
I've got a template ready to go that I can share with Tara or whoever the right person is that you tell me. I can just shoot that over and, put the right person's name in it, and then you can take it from there and change it or do whatever you want with it. But basically where we are is the JISC passed this rule. And again, they are kind of like the BJA for technology. So it originated from there, appropriately, I guess that's what I mean to say. And they passed it with only one no vote. And then it went to the Supreme Court Rules Committee and almost died again, which, I just want to hide under the table after this. I gotta tell you. But we managed to pull it out of the tank. And so now it's before the Supreme Court for comment. And the comment period ends on September 30th. So there's not a ton of time left to get a comment in. But what happened last time is a bunch of people from King County sent comments in against it because that was kind of the divide at the time in terms of this policy issue. And other people didn't write in supporting it. This time, the tide has turned, I believe. And like I said, I'm aware of at least 7 letters of support that are either done or in the hopper. And I haven't seen any letters against, although they tend to come right at the last minute. So I wouldn't be surprised if some did. But I just think from what I'm hearing out there from the Superior Court Judges Association, the District and Municipal Court Judges Association, various other groups I've spoken to, is that people now understand the importance of this in terms of public safety and access to justice. You all may remember a few years ago, there was a case in, I think it was somewhere, it was around Seattle, like Bellevue or something, where this whole family was run over by this guy. And one of them was killed, and 1 or 2 of them were killed, and one was injured. And part of this guy's history was actually out of Seattle Municipal Court. And it's cases like that I read in the paper that I think, man, we are just like one little piece of information away from some kind of disaster and somebody being let out who shouldn't be let out because we don't have part of their criminal history or something. Or you've got, someone in front of a judge with a domestic violence order on the table, and you don't have all of the person's history of domestic violence because we haven't been able to share all of the data properly. Those are the kinds of things that keep me up at night. So at this point, do you believe you will have support from King County and Pierce County? No. I see. Okay. Because the one person who voted against it on the JISC is the King County clerk. She just changed her mind. And the odd thing is she's already connected up to the data exchange. So I really do not get it. But, some people are just in their positions, and it is what it is. So I don't know whether there will be, I do know that she went to the SCJA last week. And from what I heard about the discussion, came in thinking she was going to have a victory and kind of didn't by the end of the conversation. So it just feels like the appetite for this thing has definitely changed over these several years.
Okay, I had Governor McBride. He may have withdrawn his hand. No?
Yes.
Yeah. Okay, and I have Chief Regulatory Officer Garcia.
Hello. I'm just wondering if this change will modify how we currently transmit data to AOC on a weekly basis.
Who is we?
WISBA.
Oh.
Sorry.
No, I don't think so. I'm not even aware of whatever that process is, but it's not impacted by this. No, this is for information that's coming from courts that have their own systems. So I've kind of watched over the years this or that or the other issue with the data transmission from the Bar Association, but that's a process that we already have established between AOC and the Bar, and there's no problem there. That's not what this is.
Okay. Great. I just had to ask. Thank you.
Okay. Now seeing as our hands raised, I'm going to proceed to a roll call vote. Governor Abel.
Aye.
Governor Angelvale.
Aye.
Governor Clark.
Aye.
Governor Grabicki.
Aye.
Governor Higginson. You might be on mute, Governor Higginson.
Aye.
Governor King. Governor Knight. Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Shichetti.
I abstain only because I understand that I may be writing that letter.
Governor Stevens.
Aye.
Governor Swagel.
Aye.
Governor Tollefson.
Aye.
Governor Williams-Ruth.
Aye.
11 in favor, 1 abstention. The motion passes. This will go to the office of the president. I'm putting it in the hopper here in the office box. I don't know if I'll get to it before the end of the day tomorrow, so we'll see what happens there. Thank you so much, Ms. Clenane. If you could transmit what materials you may have prepared to Kyle Shichetti and Tara Nevitt, that would be most appreciated. Thank you.
And if you don't have Kyle's contact information, I'll get it to him if you send it to me.
Okay, perfect, because no, I don't. And if you'll indulge me for just a moment, I don't know if Bob has already reported this to you, and I don't usually get the opportunity to report to the Bar Association Board, so I wanted to just give you this nugget in case you haven't already heard it. We've had lots of stops and starts and bumps along the way for the limited jurisdiction case management replacement project. But one good thing that has come out of, we just got the contract signed on the 1st of September, finally. And one thing that has come out of the way we are rolling it out is we figured out that we can actually implement electronic filing way before we can implement the case management system. The case management system has to be rolled out. It's actually the biggest project we will ever do because of the number of courts we're talking about. And so that's going to be rolled out over 5 years in these geographic groups. And we will be communicating with the judicial community about all of that. But I want to make sure that we don't leave the Bar Association and the ATJ stuff out of the communications in general. But as a preview for that, I will tell you that within about 6 months, we should have the pilot course up on e-filing. And that includes e-service, by the way, which is extra cool. Those pilot courts are on Pierce County for lots of reasons, including complexity of caseload and configuration and nearness to Olympia, where all the AOC stuff is. And but that will be in 4 courts in Pierce County in about 6 months. That's Pierce County District Court, Tacoma Municipal Court, Gig Harbor, and Fircrest Ruston. And then within about 6 months from them, so then about a year from now, it will be statewide. And I'm working right now with the DMC Rules Committee on a model local rule, GR30, that will kind of lay out all the rules around that. But I just thought that you all might enjoy knowing that filing and serving will get a lot easier, at least at the limited jurisdiction level. And there are some superior courts that are applying. Long story why the superior courts didn't do it in the first place when they could have, but they're coming online as well with e-filing, but sort of more slowly. So I just wanted to share that because I figured that would probably be good news for any practitioner.
Well, thank you so much. We really appreciate all this technical expertise and reporting, and thank you so much for being here.